We need to make a few final notes before concluding our discussion on criminal homicide offenses in the Texas Penal Code. First, it's important to understand not all acts of causing the death of an individual that are in the Penal Code are considered criminal homicide. Intoxication manslaughter is found later in the Penal Code and not included in the definition of criminal homicide. The Penal Code goes on to clarify that the criminal homicide chapter applies to the death of an unborn child unless the mother has an abortion performed by a doctor or the child is aborted by use of drugs in accordance with law. Finally, the Penal Code clarifies what's known as lesser included offenses for criminal homicide. Lesser included offenses are found throughout the Penal Code, and it is basically referring to what a defendant can be charged with versus what the jury or judge can find them guilty of at trial. In the case of criminal homicide, a prosecutor can only charge a defendant with one offense for every set of elements of the offense completed. So if you cause the death of one person in the course of committing a felony, you can only be charged with one count of murder. However, at your trial, if permitted by the judge, the jury, upon hearing the evidence, may decide to convict you of either murder or a lesser included offense. They may decide the evidence only proves manslaughter beyond a reasonable doubt or even criminally negligent homicide. Lesser included offenses apply to offenses below the one you're charged with. In this case, you can't be found guilty of capital murder by the jury. They can't go up the ladder, only down.